Judge Liman seems to be cleaning up a lot of the motions that were remaining on the docket in the Blake Lively versus Justin Baldoni case. He hasn't yet ruled on the motion for summary judgment or the motion for judgment on the pleadings, and he's now set a hearing for next Thursday, April 2nd, which the public can dial into, where they're going to talk about some of the issues they're having ahead of the pretrial motions being filed. Right now, we've been seeing him clean up a lot of the stuff that's still on the docket. Just given the volume of things he's ruling on right now and the stuff that's come out in the last couple of days, I have to kind of pick and choose what I get to right away. But I did see this sanctions motion by Lively and Reynolds that he just ruled on, and I wanted to get to that one. So let me show you the ruling and what the conclusion of the ruling was, and then we'll go back to kind of look at what exactly Blake and Ryan were asking for. Because there were so many sanctions motions, we need a little bit of a refresher as to which one this even was. So here's the order on this sanctions motion. It says Blake Lively and Ryan Reynolds each move pursuant to FRCP 11 for the imposition of sanctions against Sarowitz, Heath, Nathan, Abel, It Ends With Us movie, and their counsel, Liner Friedman and Meister Selig. Lively and Reynolds seek sanctions in the form of attorney's fees and costs that she incurred in defending Wayfarer Studios via Lively and a formal reprimand. For the reasons that follow, the motion is granted in part and denied in part. So before I go through the whole ruling for you guys here, let me just kind of summarize my takeaway from what the judge wrote. He says here in the conclusion that the motions are granted in part and that Liner Friedman and Meister Selig are given a formal reprimand for violating Rule 11 by making claims that were legally frivolous and factually baseless. This applies to some of the Wayfarer claims, but not all of them. However, the court has declined to award any monetary sanctions. So like I said, some of the claims here were found to be legally, unsupported or frivolous, mainly because certain plaintiffs had no basis to bring them at all. So for example, the Wayfarer parties brought a claim of civil extortion. The court said that Sarowitz, Nathan, Abel, and It Ends With Us movie LLC, they had no factual basis to sue for civil extortion. Now, notice Justin Baldoni's not included in that. Jamie Heath is not included in that. So even if the allegations of civil extortion were taken as true, they did not apply to Sarowitz, Nathan, Abel, It Ends With Us movie LLC. So the court is not saying that every single plaintiff brought forward a frivolous claim with that civil extortion claim. He's saying that some of the plaintiffs should not have been included there. They do not apply to those plaintiffs. Another example he's going to give is that breach of implied covenant of good faith and fair dealing. That would require the plaintiffs to have a contract with Lively. But some of the plaintiffs did not. So Sarowitz, Nathan, Abel, Heath, they did not have a contractual relationship with Lively, so they didn't have a legal basis to bring that claim. What this does not mean is that all of the claims that the Wayfarer parties brought in their lawsuit were totally frivolous and made up and devoid of factual information, because we'll notice when we go through this that one of the things that was not sanctionable was the defamation claim, especially against Ryan Reynolds. The court found that that was not frivolous. So I'm sure you're going to see lots of headlines today in the TMZs and the People magazines of the world that'll say, oh my God, Wayfarer parties and Justin Baldoni brought forward a frivolous lawsuit. The court says their lawsuit was frivolous. That's not what's going on here. Some of these plaintiffs should not have been included in some of the claims, but the court didn't even find it a big enough deal to rule any monetary sanctions were necessary. And the judge in his ruling even says there's no basis to believe that the allegation of the sanctionable claims imposed any great burden on Lively and Reynolds beyond the burden that they faced to address the claims, which are not sanctionable. So here's the sanctions motion, which was filed all the way back in May 2025. It's been almost a year. And as I'm looking at this and I'm kind of skimming over the judge's ruling in the background, I'm thinking there's enough of a recap in the judge's ruling that we don't really need to go over this whole motion again. So let's go back to the ruling and let's read what he looked at, what he considered, and why he made the decision that he did. One thing to pay attention to, when he says Rule 11 plaintiffs in this ruling, it's referring to Sarowitz, Heath, Nathan, Abel, and It Ends With Us LLC. So the judge notes that Brian Friedman and Mitchell Schuster, signed the first amended complaint on January 31st, 2025. It pleaded 9 causes of action. In this paragraph, the judge is kind of outlining what the causes of action in the Wayfarer lawsuit were. I don't think we really need to go through all of this again, but I'll name the causes for you. First, they had civil extortion. Second was defamation. Third was false light invasion of privacy. Fourth was breach of the implied covenant of good faith and fair dealing. Fifth was intentional interference with contractual relations. Sixth was intentional interference with prospective economic advantage. Seventh was negligent interference with prospective economic advantage. Eighth and ninth were only against the New York Times for promissory fraud and breach of an implied in fact contract. So all but 8 and 9 were causes of actions that were asserted against Blake Lively. All but the 4th, 8th, and 9th causes named Reynolds as a defendant. And then the judge also notes here that all except for the 3rd cause of action was pleaded on behalf of all of the Wayfarer parties. And like I was trying to explain earlier, the problem is that it was pleaded on behalf of all of the Wayfarer parties, where that was not necessarily appropriate based on the law in some cases. And this is a little bit of me thinking out loud here and trying to put it in like plain English to what I understand. Remember, I'm not an attorney. Always check with the attorneys who follow this case. But as an observer and somebody who's been watching this stuff since the beginning, I'm starting to pick up and understand a lot more than I used to. You know what I mean? So for example, like tortious interference claims, like interference with contractual relations, that was brought on behalf of all of the Wayfarer parties. But the claims were based on a relationship with WME. And the only Wayfarer parties who had that relationship with WME were Baldoni and Wayfarer Studios, meaning that Sarowitz, Abel, Nathan, It Ends With Us movie, they did not have a basis to have that claim brought forth on their behalf because they weren't part of the relationship with WME. They can't sue Blake Lively for interfering with a non-existent relationship or contract between them and WME. Hopefully that makes sense. So where Justin Baldoni and Wayfarer did have grounds to bring that kind of claim because of the contract that Justin had with WME, someone like Melissa Nathan would not, because Melissa Nathan did not have a contractual relationship with WME. Therefore, Blake Lively or Ryan Reynolds could not interfere with a contract that she didn't have. So the court is saying it was inappropriate or frivolous for Melissa Nathan to be included in that claim. And I probably could have read more of the ruling before I stopped to explain my thought process to you guys. However, because of my ADHD brain, if the thoughts don't come out right now, they might never come out at all. So they just go away. They disappear into the nothing. And then I remember later on that I had a great idea or something that I really wanted to say, but I have no idea what it was. Okay. So the judge is still explaining the background here. Lively and Reynolds moved to dismiss the first amended complaint for failure to state a claim for relief. On June 9th, 2025, the court issued an opinion and order granting the motion to dismiss. I'm not going to read this whole paragraph here, but he's basically explaining that on June 9th, the court issued the opinion and order which granted the motion to dismiss. And he explains why some of these causes of actions were dismissed, which we all saw when we read the ruling. On April 22nd, while that motion to dismiss was pending, Reynolds served each of the Rule 11 plaintiffs and their counsel with letters pursuant to FRCP 11C, demanding, among other things, that Sarowitz, Nathan, Abel, and It Ends With Us movie withdraw their civil extortion claims, and that the Rule 11 plaintiffs withdraw their defamation and interference claims. On April 23rd, Lively served a similar letter, demanding that Sarowitz, Nathan, Abel, It Ends With Us movie LLC withdraw the civil extortion claims. So basically saying to some of the Wayfarer parties, not all, that you should not have brought these claims against us, you need to withdraw these, this is improper. But the Wayfarer parties did not want to do that, so they didn't withdraw those claims on behalf of those parties. I'm not really sure why, to be honest. I have absolutely no idea if there was any benefit to them not withdrawing that, but weeks later, Lively filed this motion for sanctions on May 19th, and so did Reynolds the next day. So that was the background that the judge included in his ruling. This is the discussion. He says, Lively asserts the complaint was filed for the improper purpose under FRCP 11B1 of seeding a harassing media narrative against her and without any legal or factual basis. She also said that with some of these claims, the plaintiffs violated FRCP 11B2, which means the claims need to be warranted by existing law. They need a valid legal basis. And Rule 11B3, which means they need to have factual support or will likely have evidentiary support. Reynolds made similar claims here. This paragraph continues talking about Rule 11. It says that when lawyers file something in court, they're basically signing a certification that says it's not filed for a bad reason, it's legally valid or arguable, it has or will have evidence. Those are the three things we're looking at here. He writes, Rule 11C in turn permits a court to impose appropriate sanctions for violations of Rule 11B. Sanctions imposed under Rule 11C must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. The sanction may include non-monetary directives in order to pay a penalty into court, or, if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation. And then he quotes here, when a court determines that Rule 11 sanctions are appropriate, it has significant discretion in determining what sanctions, if any, should be imposed for a violation. So the judge here has pretty broad discretion in whether or not to sanction these guys and how severe the sanctions should be. Like it could be serious financial penalties. It could be a slap on the wrist. And based on the ruling here, when we kind of went to the conclusion right away when we started this video, it seems like he gave them a slap on the wrist. The standard for triggering sanctions under Rule 11 is objective unreasonableness and is not based on the subjective beliefs of the person making the statement. So even if the lawyer in question is saying, no, I really thought this was a good claim, the standard is, would an objective, reasonable attorney consider this to be a good claim? It's not asking, did this lawyer honestly believe that it was a good claim? And you'll note down here, he says, even though not signed in subjective bad faith. So even if the lawyer really believed it to be a good claim, they can still be sanctioned in violation of Rule 11 if it's found to be legally unreasonable or frivolous, despite that attorney not having bad faith. And then the judge writes here, it is not a defense that the offending party acted with a pure heart, but an empty head. And this is what I'm talking about. Like, I don't know why they didn't withdraw those claims on behalf of just those plaintiffs, because Justin Baldoni and Wayfarer Studios still had grounds, it seems, to bring that claim at that time, but I don't know why they wouldn't withdraw the contractual claims as it relates to WME on behalf of like the publicists, you know, because the publicists didn't have a contractual relationship for Ryan Reynolds to interfere with under the law. Like, sure, he fucked with them in a lot of ways and what he did was repulsive, but you can't bring a specific legal claim based on contracts that don't exist. But since I'm not an attorney, there could always be strategic reasons for things that I just don't know. I don't know if they had that discussion with their clients or what made them decide not to withdraw before Lively decided to file a sanctions motion. They did have a few weeks. So I'll be honest, I don't really understand that one, but that is a question for the attorneys who covered this case for sure. For the record, I do not think that the Wayfarer party's attorneys have empty heads at all. I don't think that. But the quote is a little funny, you know? So the judge here notes that the rule is claim and party specific. So we don't look at the lawsuit like one big pile of mashed potatoes. We have to look at each claim and each specific party. Just because one claim is not valid doesn't mean the other claims aren't. And just because one claim is valid for one of the parties, say Justin Baldoni, doesn't mean that the claim is also valid for Melissa Nathan. And this statement right here is just another way to say kind of what I've been saying here. Nor even if one of the plaintiffs has a claim against the defendant, does the rule permit other parties to sue that same defendant absent a legal basis. So Justin Baldoni having a factual and legal basis to sue Ryan Reynolds and Blake Lively on some counts does not give automatic permission for like Melissa Nathan to bring a claim against those defendants for the same thing. The judge writes here, the Wayfarer party's first cause of action asserted a claim against Lively and Reynolds for civil extortion. It asserts in boilerplate fashion that the Lively parties, meaning Lively, Reynolds, Sloan, Vision, and the New York Times, made threats to the Wayfarer parties that they knew to be wrongful. The threats included demands that money, property, services, or other sources of value be conferred upon the Lively parties without consideration or contractual entitlement, that the Wayfarer parties complied with those demands, and that they were harmed as a result. So to break that down a little bit, he's describing Wayfarer's first cause of action as saying Lively, Reynolds, and all these people threatened us and forced us to give them something of monetary value or some kind of value. They didn't have any legal right to demand that from us, Wayfarer, and Wayfarer was harmed because of it. And Wayfarer's talking about that demand for a public apology for problems that occurred on the set, where Lively and Reynolds said if they would refuse to give that apology, the gloves would come off and Wayfarer would be attacked. The Wayfarer parties also alleged that Lively demanded with extortionate threats that Baldoni, Heath, and Wayfarer submit letters to the PGA in support of her certification for a PGA mark. They said that Lively continued to extort them, that Wayfarer and Baldoni resisted, but that ultimately they drafted and signed a letter of support on her behalf. The court previously explained why those alleged threats failed to state a claim for relief against any of the defendants. For purposes of Rule 11, however, what makes the civil extortion claim sanctionable is that the factual allegations do not support a claim for relief by Sarowitz, Nathan, Abel, or It Ends With Us movie against Lively or Reynolds. So again, here the judge is not saying that Justin Baldoni and Wayfarer making that claim was frivolous and sanctionable. He's saying that including Sarowitz, Nathan, Abel, and the LLC in that claim, that's the sanctionable thing, because these parties, these plaintiffs, did not have legal grounds to bring that claim because they were never involved in this PGA letter. They never had to sign the letter. The accusations involve Wayfarer, Baldoni, and Heath, but not the others. Therefore, the others cannot just bring this claim that, you know, legally has nothing to do with them. From an observer's perspective, you can see how this affected all of them, but legally, the standard for bringing a claim in a federal court is different than the public assessing a situation looking at how that affected all of these parties and saying, yeah, that's gross. Because unfortunately, not all bad behavior is something that can be kind of fought over in courts unless you meet a certain legal standard to bring a certain claim. And that usually means having more direct involvement than like someone like a Sarowitz or an Abel did for these specific claims. Not all the claims, but these ones. And the judge notes that here. The four of them simply had no basis to sue Lively or Reynolds for civil extortion. The second cause of action implicated in the present motion is the claim for defamation against Lively and Reynolds on behalf of all defendants. The claim is based on the allegations that the Lively parties made one or more statements to persons to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and retaliated against Lively and others for reporting the alleged misconduct. Reynolds argues that the claim against him is sanctionable on the limited basis that it does not allege that he personally made any defamatory statements to third parties. But a party can be held liable for defamation under New York law on a conspiracy theory. Reynolds' motion directed to the second cause of action is therefore denied. So they denied any sanctions based on the defamation claim, because there was a basis in law for them to bring that claim against him. In this paragraph, the judge is talking about the 5th through 7th causes of action, and that relates to that contract or economic relationship between Wayfarer and WME. And we kind of talked about this in the beginning, so I don't think we need to harp on that too much, but the judge sums up here. The Wayfarer parties have not identified even an arguable basis in law or fact for any Wayfarer party other than Baldoni and Wayfarer to assert these claims, as no other party was implicated in the contractual relationship. And the 4th cause of action was kind of along the same lines. It involved a contractual relationship with Lively. And where Baldoni and Wayfarer had grounds to argue a claim like that, he notes down here, there is no, existence of a contractual relationship between Lively and Sarowitz, Nathan, Abel, or Heath. A claim by a person that the defendant has committed a tort or breached a contractual relationship is not to be made lightly. It can carry reputational consequences, even if that same claim is properly made by another party. The court is authorized to impose monetary sanctions, including a penalty or attorney's fees for such conduct. In this case, however, there's no basis to believe that the allegation of the sanctionable claims imposed any great burden on Lively and Reynolds beyond the burden that they faced to address the claims which are not sanctionable. The sanctionable claims did not place any burden on the court. Accordingly, the court limits the Rule 11 sanction to a reprimand of Liner Friedman and Meister Selig and their respective firms for violating Rule 11. So again, slap on the wrist. I guess another way of looking at it would be like if Ryan Reynolds had also brought claims of sexual harassment against the Wayfarer parties. We know that Ryan Reynolds was not sexually harassed. So it would be kind of ridiculous for them to bring a sexual harassment claim on the part of Ryan Reynolds. That would be a frivolous claim. That would be a claim that has no basis in law or fact. And that's kind of in the same vein that Melissa and Nathan should not be bringing forth any claims related to like a breach of contract with WME or Blake Lively when she never had a contract with WME or Blake Lively. So, I mean, that makes sense to me. And I think that he obviously didn't overdo it with the sanctions. It was, like I said, just a slap on the wrist. I think this is fair. All right, it's getting towards the end of the workday today, so I don't know what, if anything else, he'll decide to clean up this afternoon. But if anything else pops up, I'll be back. Thanks for watching, guys, and I'll see you all soon. Don't forget to hit the like button for me because that helps me out a lot. Thanks. Bye.